to be looking at family law. That is a branch of law that is quite wide. We are going to look at specifically an act called the Status of Children Act. In the UK, status is pronounced status. So it's the Status of Children Act. Well, we all know it's a reality of Caribbean society that many children are born outside of wedlock. Well, this is a matter that's worldwide now, but I am concentrating on Caribbean. So I will be specifically targeting the Caribbean country. Well, this act has been enacted in the majority of Caribbean countries because in the region we have established laws to end discrimination against children. The reason why I am saying this is because this act gives children born to unmarried couples the same rights as those born to married couples. The act came into force on the 1st of January 1992. When it came into force, it abolished the word bastard, because children born out of wedlock was once referred to as bastards or illegitimate. Now, from the commencement of the act, all children will be of equal status. This act applies to all children born to Grenadian parents, regardless of whether that child was born in Grenada or elsewhere. And now I'm specifically dealing with Grenada. Under Section 4 of the Act, all children born before or after the Act it applies to. The father of an illegitimate child. There is a presumption under the Act that the person who was married to the mother at the time the child was born is the father of the child. That section goes on to say, unless it could be proven to the contrary, that person shall be recognized in law as the father of the child. There are various circumstances when this will occur. Firstly, under Section 5(2)(a), if the person was married to the mother of that child and that marriage was terminated by death, nullity, that's when the marriage was nullified by law, or divorce. This is before the birth of the child. The second instance, B, is where the person marries the mother of the child after the child was born, and that person acknowledges that he is the natural father. The third instance is where that person was in a relationship of some permanence. That is where the two parties are not married, but there's some permanence in the relationship. And at the time of the birth, or the child was born within 280 days after the parties ceased to live together. The fourth instance is where the person is recognized by a court of law to be the father of the child. We'll come back to that. And the fifth instance, E, this is where the person has, by an affidavit of paternity, and the affidavit together with a declaration by the mother confirms that that person is the father of the child. But of course, that affidavit of paternity must be recorded in the registration office. 6, which is F in the Act, where that person has acknowledged in proceedings, that's proceedings before the court, that he is the father of the child, and that person has signed and executed a deed to say that he's the father of that child. 7, this is G in the Act. That person is alleged to be the father of the child, and he's given his written consent to adopt that child, and that child has his name. And finally, H, where a person is alleged to be the father of the child, and by his conduct implicitly and consistently he has acknowledged that he is the father of the child. So under section 5.2, there are various reasons where it can be proven that a father, a man, a person is recognized by law to be the father of the child. Well, let's move on to section 5.3 of the Act. This is where paternity is presumed. And this is where there are circumstances that give rise to presume the paternity of the child, and there's more than one father has come forward. In these instances, it shall be a matter for the court, on the evidence put before the court, for them to decide who is the father of the child. Under section 6, there are instances where a marriage is void. When a marriage is void, it's as if it never occurred. even though this is a situation that happens, of course, children may have been born before the court has deemed that the marriage is void. In these instances, it would be presumed that the person is the father of the child. Now, shall we go back to section 3? I referred to children being of equal status, whether they were born in or out of wedlock. We all know in those times when a child, or even before the act, when a child is born out of wedlock, prior to the commencement of that act, that child will not automatically fall under the inheritance rules. They cannot automatically inherit from their parent, the father. Well, under this act, regardless of if the parents are married or not, a child can, after 1992, inherit from the father. So this is where it abolishes the distinction between children, and those children will have equal status as if their parents were married at the time they were born. Right, we've spoken about the presumption of paternity. But under section 7 of the Act, any person having an interest in a child may apply to the court for a declaration of paternity. That is, for the father to be recognized in law to be the father or mother, as the case may be. So this is where section 5 comes in, because where any of the instances that has arisen from section 5, I gave you instances from A to H. This is where they can make an application under section 7 of the Act to say that the child is their child or another person's child. The more usual way that we know of the declaration of paternity is to obtain a blood test, a DNA test. This is under section 11 of the Act. An application can be made to the court to determine the parentage of a child. The mother, the father, an interested person, or the court may direct for a blood test. Where a person refuses to submit to a blood test, the court may draw such inferences as it thinks appropriate. So, of course, if you refuse a blood test, that could determine whether you're the child. The court could say, yes, you are the father of that child. So it's much better for you to submit to a DNA test. Likewise, under Section 12, the court may give directions that such persons shall undergo such scientific or medical tests other than the blood test to determine the issue of parentage. At present, it is quite an expensive procedure within Grenada. I believe it is around $1,400 to obtain a blood test, a DNA test, to prove paternity. Just a simple test could do that. The results are 2 to 3 weeks before it is obtained. So in Grenada, a DNA test, blood test, is quite usual if it is asked for in a maintenance action. In fact, the first hearing, they actually ask the alleged father if he is the father, if he accepts paternity. If he does not, there's an opportunity there for a DNA test to be obtained to determine paternity. So it is a very simple procedure to determine the status of a child in Grenada.
So, it's very interesting stuff there, Miss Willis.
I'm glad you think so, and I hope the viewers will also see that it's very interesting material, and it's something that all individuals within the Caribbean should know.
What are the common misconceptions with family law with regards to children?
Explain what you mean by misconceptions. That's a very wide word.
Well, maybe inheritance and stuff like that, where the person may be born into the family and may have been given a father's name. However, they're not actually blood related because the child was from another person and they've come in as a blended family, that sort of thing. And then they're trying to claim inheritance afterwards because they've got that name, but their blood is not there. And then the family decides to come in and say, look, you're not actually blood related. You're just by name, but actually you're not blood related. We mean more than you do.
Well, that happens quite a lot, but even if they're not blood related, they may have taken on that child. It may be a stepchild.
Yes.
And there's clear rules on inheritance and the rules on inheritance. And a stepchild, it is determined by blood. and half of full blood. There is no leeway for where there's no blood relation. But there is provision, the family and inheritance provisions, that if a child has relied on an individual to take care of them, they may fall under the provisions of that act to claim assistance.
Another situation, which I am quite aware of, where mother has had children from two different men, and then they've got into a relationship with another man, and that man has given the child his name and has looked after both the children and given them his name. Then he's passed away. They're still left with that name. However, that name doesn't tie them to any family tree whatsoever. What about that situation? Would you advise them to stay with that last name, or would you advise them to go to the names that link them into their family tree?
Right. Well, remember we spoke about that under Section 5, where there's various exceptions for presumption of paternity. And that's another one where that child has been carrying that person's name for a long time. They fall under that act, under Section 5.2. Do you recall?
Yes. So basically, if the person's name is Wilson, say Wilson is the name of the man that has given his name to these children, but these children's names are, I don't know, Frankinson and Anderson. They're the two families that child's actually from. But he's taking the name as Wilson. So if that young man's name is Steve, and he takes on Steve Wilson throughout his life, and the actual Wilson, that father, or the guy who's being the father to that child or those children, and Wilson dies, they've just carried the name by the legacy of somebody else, but they're not technically a Wilson, are they?
No, but under I told you, under Section 5 of the Act, specifically Section 5.2H, it falls under there. I'll read that for you again. A person who is alleged to be the father of the child has given written consent to that child adopting his name. So basically, if the child has adopted the name and there's written consent that the child can carry that name, yes, there's a presumption of paternity there. There's written consent.
But if that child decides to say, you know what, or if that child has children and is still taking that name Wilson on, and Wilson's a dead man now, they've taken it because obviously the father, who the child at the time has children, and they will certainly become Wilson as well. Then what happens?
Right. Remember, I spoke about the written consent.
Yes.
If Wilson parents have that written consent from that man that he's taken that child on,
yes,
then their children will call that person grandfather, great grandfather, and so forth. There's written consent that he has taken on.
But he is dead now. He is dead now. Now he's dead, and now the name Wilson is still there. He's the only person connected to that family now, Wilson, because he gave his name to protect the woman, because the woman looked bad.
You're missing the point where I keep saying written consent. If there's a written consent anywhere from that individual, then the generations can hold on to that name. You see what I'm saying?
Yeah, but
if there's written consent before he died.
That's true. That's not the point. The point is, what about the actual family tree of the bloodline of those children?
Well, it goes to say straight away, it's not a bloodline, is it? We're talking on presumed paternity.
Mm-hmm.
We're not talking about the bloodline. You're talking about two separate
So
things.
yeah, so what I'm saying is then that name Wilson would have to. They've got the choice to keep that name or get rid of that name, and then if they get rid of that name, then they become part of the another family tree, the original family tree. Do you understand what I'm saying there?
All right, that's a name. We're going a bit deeper than that. That's just a name.
But a name
Anybody
gets,
can change their
yeah,
name by default.
yeah, but a name gets you into a family tree. It brings you back into your family tree because it's somebody who's taken somebody else has taken the name, right? You're taking somebody else's name, somebody else's family name.
Yeah, but that family tree falls under the mother and the father, and that person would not be under only if you have the written consent, and you'd have some sort of note showing that it wasn't that name, wouldn't you? You wouldn't. You would have something denoted in the family tree to show that it's not a direct bloodline. They usually, when I'm just looking in my mind's eye of a family tree,
Yeah.
and you usually have two names, and then it's split off when it
Yes.
comes.
Yes.
You would have it like that.
Yes. Those are the two names you'd think about normally. But if somebody else comes in and gives you a name, which we say Wilson Wilson has been the name, that family tree, those two family trees are for that point in time. Once you become Wilson, those family trees don't matter. You'll have to go and get rid of that name Wilson to get yourself back into those family trees. Correct?
Family tree deals with bloodline.
Yes.
Paternity does not always deal with bloodline.
So which is more important? When you talk about family history and legacy, surely that person.
Right. You're still losing the point of this act. Okay?
Okay.
Before this act, children who were born out of wedlock
Were
were
illegitimate. Right. They were illegitimate.
That's right.
Yeah.
There's many children born before 1992. Well, mostly in the 60s, going backwards, 50s, 40s, that do not have a surname on their birth certificate because their parents were not married.
Mm-hmm.
In the colonies, if you was not married, it goes without saying the father's name would not be in the father's section of the birth certificate. There was a common occurrence through the colonies that the father would put his name as the informant. Yeah. But he is the informant, not listed as the father. So the Status of Children Act does away with all that. You understand?
Yeah.
You don't go by what's on the birth certificate. You go by the act. If somebody has taken you on as their child and you have adopted their name, under the act, you are their child. You are not illegitimate. It abolishes the word illegitimate to make all children of the equal status. This is separate from a bloodline family tree. A family tree rests on the blood. Who is connected to whom by blood? The Status of Children Act is not about blood. It's about paternity. Who is the legal father? Here I said the word legal. In the eyes of the law, they're seen as the father. Understood?
Yeah, I get you. I get you. I understand it.
So it's completely different from
Legal and blood.
adoption.
Yeah, got it.
Say that
Got it.
again.
Legal and blood. Got it. Got it.
Right.
Aha.
As I've said to you, many individuals over the age of 60 whose parents were not married, their birth certificate does not have a surname. It just has their Christian name.
So now, could these people just go along and get these surnames now and things like Depol and stuff? Would you advise them to go and get those last names now because of the
Yes,
law?
yes, because you cannot get a passport with only one name. You cannot get a driving license with only one name. This has been disputed because I believe there's one person I've come. They've only got one name. They have not got a surname or Christian name.
So celebrities who've got one name.
Thank you very much. Like I'm showing my age now. In the UK, Lulu.
Yeah, Lulu.
Well, you know that's not her. That's a stage name. That's not her birth name. But in the Caribbean, in the colonies, you only have your Christian name, Beverly, John. When you go to school, they would automatically adopt your mother's name.
Okay, so let's go back a bit. When we talk about slavery, where the slave masters would put their name upon the slaves, what about that? How does that tie into things, or does it even matter?
That has brought about another issue of names. That's the reason why many individuals within the Caribbean have so many different names, because name wasn't important, because slaves were not human beings in those days, they were property. So when slavery was abolished and everyone went their separate ways, they adopted their plantation name. Like my plantation name is Willis. Your plantation name is Jones. So when say and the plantation owner Jones 200 slaves were free, they just adopted his name. It does not mean to say they're his blood, maybe some of them, but they're not his blood. But as Caribbean, which is basically slave territory, most individuals have adopted their slave name. Hence the reason why Malcolm is known as X, because he refused to adopt the slave name, slave surname. So that's a bit of background.
Yes, absolutely, absolutely, absolutely. Wow, interesting. Is there anything else you'd like to add before we finish, Miss Willis?
No, but every child or every individual should beware of this act in family law, especially when it comes down to maintenance. And that is a topic I will discuss. It's not a very long topic, but it's a topic that I will discuss another time, which comes under family law.